You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 2, where in this episode, I go through answering the question of whether your idea is even patentable. My name is Dr. Adam Diamond, founder and owner of Diamond's Patent Law in Los Angeles, California. I've been a registered patent attorney since 2008, and I created this podcast to help the budding entrepreneur, inventor, and startup company to guide you through the patenting process from initial idea to issued patent. If this is the first episode you're listening to, I recommend starting at episode 1, where I go through the 4 different types of intellectual property, so you can determine if a patent is actually the right type of intellectual property that you need. But if you've already determined that what you need would be covered by a patent, then the next step is to figure out whether your idea is even patentable. The short answer to the question of whether your idea is patentable is no, it's not. Now, this is really important. Ideas by themselves are not patentable. The idea is the first step, but it has to lead to an invention. And the invention is usually something that's a physical embodiment of your idea, or steps involved used to accomplish your idea. But the idea by itself is not patentable. Someone came up to me and they said they wanted to patent their idea of curing hiccups. Now, it's a great idea, but it's not patentable by itself. The person might have some invention related to curing hiccups, and that might be patentable, or steps the person could take to cure hiccups, and that might be patentable as well. For example, it could be a new drug that cures hiccups. It can be a machine that flashes light in a specific way that somehow cures hiccups. It could be a machine that someone breathes into, and once the person breathes into this machine, the person will stop hiccuping. There could be any number of types of what patent attorneys call physical embodiments that cure hiccups, but the idea itself isn't patentable. So if you hear me saying patenting an idea, what I actually mean is patenting embodiments of that idea. So once we have thought of some kind of embodiment for your idea, the next thing to figure out is whether this embodiment might be patentable. And there are 4 questions you should ask yourself to answer this. Is it patentable subject matter? Is it new? Is it non-obvious? And is it useful? This episode is just going to cover the first question. Is it patentable subject matter? And the next episode is going to go over the next 3 questions together, which are new, non-obvious, and useful. Patentable subject matter is the notion that only certain things are even eligible to receive a patent. It's probably easier to first talk about what can't be patented than what can be patented. And the common things that can't be patented are laws of nature, abstract ideas, and mathematical formulas. And I'm going to go over a few examples of each of these. Isaac Newton could not have patented gravity because it's a law of nature. It doesn't matter that he may have been the first to discover how it works, or the formulas behind it. It's just not something that's allowed to be patented. If someone else invented a device that used gravity and even used Newton's formulations for it, he couldn't demand royalties because gravity by itself can't be subject to a patent. Mathematical formulas also can't be patented. Einstein could not have patented E=mc². It doesn't matter that he derived this formula. It's considered a formula and a law of nature, so it just can't be patented. You also can't get a patent on something completely natural, even if you discover it. So let's say you were the first to find and discover a new precious gemstone. Even if you're the first person to discover this gemstone and no one else has ever seen it before, because it's naturally occurring, it's just not patentable. So what can be patented? There's a famous Supreme Court case where the court said that, quote, anything under the sun made by man is patentable. So this is really broad, and it includes machines, combinations of things put together in a new way. These are called manufactures, processes, compositions of matter, and improvements on any of these. And my guess is that for most of you, your idea probably falls into the category of a machine because you thought of some new device that you think will change the world. Besides machines, the next most common type is probably a process. For example, if you came up with a new process that filters dirty water into drinkable water by following specific new steps that you came up with, you might be able to get a patent for the process of filtering water. Even if you're just adding one step to a known process, it's possible that you could get a patent on that single step because improvements are considered patentable subject matter. Now, not everything is clear-cut on whether it falls into patentable subject matter or not, And right now, there are two main gray areas of patentable subject matter, and these are software patents and business method patents. So if your idea involves either software or a method of doing business, then you should talk to a patent attorney. The next step, after you've determined that your invention is patent eligible, is to determine whether it's useful, new, and non-obvious. And this involves patent database searching. This is going to be the topic of the next episode. So until next time, I'm Dr. Adam Diamond of Diamond Patent Law, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.